across the House.
Yeah, thank you.
My Lords, the noble Lord Clement Jones said that this was a very broad group, and it is. So I hope noble Lords will forgive me if I don't comment on every amendment in it. But I will say that I have a great deal of sympathy for the case put forward by my noble friend Lady Buscombe and my noble and learned friend Lord Garnier. And I think the addition of the word financial to clause 160 is not only merited on the case made, but is also a practical and feasible thing to do in the way that the current inclusion of the word non-trivial psychological is not. Finance, after all, can be measured. A financial loss can be measured. We know how it stands. I'll also say, if I may, before moving on, that I have a great deal of sympathy with what was said by the noble Lord Clement Jones about his amendment. And insofar as I understand them, and I appreciate they haven't yet spoken, I'm sympathetic to the amendments in the name of the noble Baroness Lady Kennedy of the Shores and Lord Allen, the noble Lord Allen of Hallam. If I turn to my amendment 265, it would remove the word psychological from this clause. But we have, in fact, debated this already in relation to other amendments. So I'm going to be fairly brief about it. I think, frankly, probably through an oversight of mine, this particular amendment has wandered into the wrong group. So I'm going to be fairly brief and simply say that it is still a very, very good idea, and I hope that my noble friend, when he comes to reflect on your Lordship's committee as a whole, will take that into account and will respond appropriately. Instead, I'm going to focus my remarks on the two notices I have given about clauses 160 standing part and clause 161 standing part. 161 is merely consequential on 160. So the meat is that clause 160 should stand part. Now, my lords, I was a curious child, and when I was learning the Ten Commandments, I'm sorry to see the Right Reverend Prelate has left, because I hope to impress him with this. When I was learning the Ten Commandments, I was very curious as to why some of them they were all sins, but some of them were crimes, and others were not crimes. And I couldn't quite work out why this was. I mean, murder is a crime, but lying is not a crime. I'm not sure at that stage I understood what adultery was. But lying was not a crime. Now, in fact, lying can be a crime. Lying can be a crime, of course, if you undertake deception with intent to defraud. If you impersonate a policeman, you are lying and you are committing a crime, as I understand it. There are better qualified noble lords than me to comment on that, but I think that's true. But lying in general has never been a crime until we get to this bill. Because this bill, for the first time, makes lying in general, that is, the making of statements you know to be false, a crime. Admittedly, it is a crime dependent on the mode of transmission. It has to be online. It won't be a crime if I simply tell a lie to my noble friend Lord Garnier, for example. But if I do it online, then any form of statement which is made, which is not true and which I know not to be true, becomes a criminal act. This is really unprecedented, and I think has a chilling effect potentially on free speech. And it seems to me right that in your Lordship's committee the government should be called to explain what they think they are doing, because this is a very portentous matter. Now, the bill states, as I say, that a person commits the false communications offence if that person sends a message that the person knows to be false and the person intended the message to cause a degree of harm of a non-trivial psychological or physical character and has no reasonable excuse for sending the message. Now, free speech actually does require one being that one should be allowed to make false statements. So this really does need to be justified. But the wording of the offence raises very substantial practical issues. How is a court meant to judge what a person knows to be false? How is a committee of the House of Commons meant to judge uncontroversially what a person knows to be false at the time that they are saying it? I say again, what is non-trivial psychological harm? And what constitutes an excuse? None of these things are actually defined. Please don't tell me they're going to be defined by Ofcom. I really wouldn't like to hear that. But this can lead to astonishing inconsistency in the courts and the misapplication of criminal penalties against people who are expressing views that they might well be entitled to do. And then there is the question of the audience, because the audience is not just the likely audience is not just the person to whom the false statement is directed, but could be anybody who subsequently encounters the message. How on earth is one going to have any control over how that message travels through the byways and highways of the online world, and be able to say that you had some sense of who it was going to reach and what non-trivial psychological harm it might cause when you reach them? But we're talking about this as if this criminal matter is going to be dealt with by the courts. What makes this whole clause even more disturbing is that in the vast majority of cases, these offences will never reach the courts, because there is going to be inevitably an interaction with the illegal content duties on the bill, because by definition these statements will be illegal content. And of course the providers, the platforms, have obligations under the bill to remove and take down illegal content when they become aware of it. So the platform is going to have to make some sort of decision about not only the truth of the statement, but also whether the person knows what the statement is and that the statement is false, and also what their intention is. Under the existing definition of illegal content, they'll be required to remove anything they reasonably likely believe is false and prevent it from spreading further, because the consequences of it, in terms of the harm it might do, are incalculable by them at that point. So we are placing a huge power of censorship into, and mandating it, not merely placing it, mandating a huge power of censorship onto the platforms, which is one of the things that many of us, some of us in this committee, have been very keen to resist. So I do think, just exploring those few points, that my noble friend really has to explain what he thinks this clause is doing, how it is operable, and what its consequences are going to be for free speech and censorship, because as it stands, it seems to me unworkable and very dangerous.
Before my noble friend sits down, I wonder if I could just ask him whether he would agree with me that our courts are constantly looking into the state of mind of individuals to see whether they are lying. They look at what they have said, what they have done, and what they know, and they could draw an inference based upon the evidence in front of them about whether the person has lied, is dishonest. This is the daily bread and butter of court. I appreciate the points that he's making, but if I may say so, he needs to just dial back slightly his apoplexy, because I think underlying here is a case to be made in justice to protect the innocent.
If I may, noble lords, I did not say that it would be impossible for a court to do this. I said it was likely to lead to high levels of inconsistency. And we're dealing with what is likely to be very specialist cases. You can imagine this in the context of people feeling non-trivially psychologically harmed by statements about gender, by statements about climate, by statements about veganism and so forth. These are the things where you see this happening. And for the idea that there is going to be consistency across the courts in dealing with these issues, I think is going to be very unlikely. And it will indeed have a chilling effect on people being able to express views which may be controversial, but are still valid views in an open society.
My